right? So negative liberty stopped being that much of a concern of the Supreme Court, and civil liberties in general have not been um, the focus. So going back, so the so-called rights revolution that has happened in the from the late 70s, early 80s in the Indian Supreme Court has not really been about civil and political rights at all. It's largely been about something else. Um, and that is important to understand. And this so-called populist turn of the court is literally understood best at the fact that the court has started arguing in the name of the people. Now, this is quite strange because courts are, of course, not the representative of the people, right? They are constitutional entities appointed through a process, but they have no interface with the people in any direct sense, right? So to be able to speak as people's representatives, which they're certainly not, right, is remarkable and is indicative of this so-called populist turn. And what is also important to understand about this attack on the judiciary that we see around this period, from the early 70s especially, I talked about elitism. One important aspect of the elitism, of this kind of anti-elitist rhetoric that Mrs. Gandhi and her lieutenants like Mohan Kumar Mangalam engaged in was that of the foreignness of Indian law, right? So this idea that Indian law is not Indian at all, or even the Indian Constitution for that matter, in many ways is not Indian at all. This kind of attack was central to the rhetoric of the time against the judiciary. And what was also felt was that for the first time, there was a clear articulation of the kind of a sense of crisis of the Indian legal system. Stuff that you're already familiar with, like, everybody knows about the pendency crisis in Indian courts, about the fact that Indian courts are relatively inaccessible, certainly for most of the people of this country, the poor masses. And interestingly, these problems that plagued the Indian judiciary was sought to be explained also by its un-Indian nature, that the formalistic nature of Indian courts, derived from its Anglo-Saxon roots, are somehow unsuited to Indian conditions. So the diagnosis of the crisis, the diagnosis of the reasons for this crisis in the Indian legal system was its formalistic nature, and the panacea, the kind of solution that was proposed at some level, was informalism. To move from a formalistic arrangement with procedural protections, etc., safeguards, to an informalistic approach, an approach that gave much more discretion to the judges, etc., than is usually the case. Now, this was seen as the grand solution, right? And it is particularly led by two judges, Justice Bhagwati and Justice Krishna Iyer, who were exponents of this kind of argument. Now, think about it. Sure, inaccessibility of Indian courts, the lack of access to justice is not disputed. But the solution that was felt was not to make it accessible through increasing the number of courts, making it cheaper, reducing court fees, etc. So So suppose that people are not able to access an institution. Do you try to lower the barriers to access the institution, or what do you do? Something else? You do something like change the institution itself. So A good example could be something like education, right? Obviously, for a long time, access to education institutions in India have not been easy uh, for large numbers of people.